Hello everyone, welcome to Talking Legal with TEMPLARS. My name is Francis Jarigo. I'm an associate with the Dispute Resolution Practice Group at TEMPLARS. With me today is Munachiso Michael. Munachiso is a senior associate with the Dispute Resolution Practice Group, as well as a media, entertainment, technology, and intellectual property practice. Welcome, Munachiso.
Thank you very much, Francis, and it's a pleasure to be on Talking Legal with TEMPLARS.
You're welcome. So on today's episode, we will be discussing protecting business brands through trademarks law. As you all know, people go into business with the idea of making profit, and most often they also desire to enjoy some level of protection while at it. So the critical question then is, what happens when along the line some other business or some other person begins to use the same logo or a similar logo or even maybe the same slogan?
What is a trademark? The definition of a trademark I admire the most is the one by the World Intellectual Property Organization. It says it's a sign capable of distinguishing the goods and services of one enterprise from those of other enterprises.
Can you give us like a brief idea of what it really entails?
So the first step is you have identified your name, your logo, contact your IP consultant, IP lawyer. What your lawyer does is to confirm that this brand name or logo is distinct first. Then he conducts a search on the trademarks portal, the trademarks registry portal, to confirm that no other name or logo that is similar or the same as yours exists previously. The registry are going to review your application, and where it satisfies the necessary requirements at that stage, they issue you an acceptance letter. They publish that accepted mark in their trademarks journal. However, where there is no protest, there is no challenge to your trademark, a trademark certificate will be issued to you. The journal allows for 2 months within which those challenge applications should come in.
That's a notice of opposition.
The notice of opposition. Now, your protection is at the initial stage for the first 7 years.
Oh, is it extendable?
Yes, it's subject to renewal.
Now, going further into the conversation, right? I understand that trademarks registration is kind of class-based. Can you really explain what that means? Especially for businesses that have diverse offerings, diverse products, diverse services. What definition of this class-based system?
So in 1957, a nice agreement was signed, and this agreement has been domesticated in several countries, Nigeria being one of them. What the nice agreement did was to itemize 45 trademark classes.
Okay.
Number 1 to 34 of the trademark classes relates to goods,
Okay.
while 35 to 45 relates to services. So when you decide you want to do business, we're using legal services as an example, you have to identify the particular class that relates to legal services and register under that class. Meaning that any other person that intends or desires to render legal services cannot use that your name, logo, or slogan to render legal services. But that does not mean that somebody selling tires cannot say, oh, I want to name my tires this, because he will also have to register under a different class which relates to tires as goods.
What about businesses that are into diverse industries?
You're not restricted to just the class you're registered.
Oh, okay.
Yes, you can actually register across classes. So you can identify every single class that relates to your business and register in every single one of them. Some very big brands just prefer to register in all the classes.
I've, in my experience, seen a lot of clients confusing trademarks and patents. My question is, are they really related concepts? I mean, what is really the difference between trademarks and patent?
The only thing that makes them the same is that they are both intellectual property rights that are protectable. But they are different in the sense that what they are looking out for are different things. While your trademarks are trying to protect your trade name, your business name, your logo, or your unique slogan, patents are more focused with inventive and innovative processes. So with patents, what you are protecting is the functional part of your inventive or innovative process. It's important to mention that patents are not forever. It's registered, it has a lifespan of 20 years. And as opposed to trademarks that is 7 years and renewable, patents are not renewable. So after the 20 years, it's free market. Anybody else can get involved with your inventive process.
This has been a really insightful session. Thank you very much, Munachi, for joining me. And thanks to our listeners for joining this episode of Talking Legal with Templars. In a nutshell, the essence of this conversation is whether you're an individual or a company looking to put out a brand or an invention, you should consider registering that brand under the Trademarks Act or the invention under the Patent and Designs Act in order for you to be able to enjoy the full benefits afforded under the law. Thank you once again for listening, and see you next time on Talking Legal with Templars.